Everyone, and welcome to the University of Nicosia webinar on navigating the new digital rulebook, artificial intelligence, legal technology, and EU platform regulation. Now, before I get into the specifics of the webinar, I would like to say a few words about our new distance learning master's degree in technology regulation. And this is exactly what this webinar is about, to give you a taste of what our program looks like. So let's start with a small video. I would like the distance learning unit to share with us the video for the program, please. Welcome to the Master of Arts in Technology Regulation, a program designed to deepen your knowledge in fields of legal science directly linked to disruptive technology. Our program aims to allow you to explore fields, cutting-edge issues such as the Internet of Things, big data, the metaverse, blockchain, artificial intelligence, and these from the perspectives of human rights, personal data protection, cybercrime, intellectual property rights.
This program is designed to maximize your employability prospects in the digital economy sector. Upon completing our program, you will be prepared for various roles, such as IT designer, legal counsel, legal developer, computer scientist, business strategist, and legal compliance officer. Here you get the ability to generate theoretical and empirical analysis, solve complex legal problems, evaluate regulatory issues across national and international levels.
The curriculum exposes you to the transformation of legal science by new and emerging technologies, taking into account comparative elements in a global context. The distance learning format of the program gives you flexibility without compromising on academic rigor, preparing you to engage with present and future challenges.
You will broaden your understanding on the legal tech spectrum, making yourself a very valuable asset in today's interconnected and evolving technology landscape. Join us to expand your horizons and take a leading role in shaping the future of technology regulation. We're excited to support your learning journey and professional growth.
Thank you very much. I guess this gave you an idea of what the program looks like. You need to bear in mind that this is not for law graduates only. Also other disciplines such as political science, economics, business, media, engineering, IT professionals, or even individuals that aim to become policy influencers, tech regulation experts, or legal innovators in the digital economy are admissible to this program. And of course, this program is flexible because it's distance learning. You can learn at your own pace since it is offered online, and also makes it easy to balance your work with other, let's say, personal or professional commitments. I don't want to spend any more time on the program. We'll go straight into the content of this webinar. And we have two very distinguished scholars with us. We have the famous Fedon Nicolaidis. He is a professor of European Economic Law at the University of Maastricht and a visiting professor at the University of Nicosia and the College of Europe in Bruges in Belgium. He has been educated in the United States, the United Kingdom, and the Netherlands, and he holds a PhD in law and a PhD in economics. He has acted as advisor to EU institutions such as the Commission, the European Parliament, and the European Investment Bank, and national authorities as well as companies. And he's going to speak about the European Union's Digital Markets Act from a competition law point of view. So you have the floor, Professor Nicolaidis.
Well, thank you very much. Thank you for your kind words. And of course, good afternoon to everybody. I will now share my screen.
Just to remind the audience that after we conclude with the two talks, we'll take questions on the end and there will be a small discussion. So you can hold your questions and you can ask them after the speakers have finished.
So I would like to say a few words about the European Union's Digital Markets Act, which is intended to protect you and me from perhaps abusive behavior by the large platform operators. Well, I suppose, again, I think it's impossible to imagine our lives anymore without the internet, without access to this wonderful new technology. But I will explain in a minute why the internet, our reliance on providers of services online, creates a problem. And then I will very briefly explain what the solution is from the European Union's perspective. And that solution has been in the definition of regulatory obligations that are imposed ex ante on the operators of large digital platforms. And I will conclude by saying a couple of words on at least what I think about this ex ante regulation about the Digital Markets Act. Well, in order to understand where the problem lies, let's think about it for a moment. When we interact online, basically, we are dealing with a market with two sides. There is a seller or a provider, and there is a consumer or a buyer. And they're brought together, they're able to interact, they're able to transact through an intermediary. That intermediary is the digital platform. And there are many examples. Whenever we use our credit card, we go through a platform. Whenever we play games with friends who happen to be many, many kilometers away from us, we go through a platform. When we purchase a book from Amazon, or we purchase whatever else you buy online, we go through a platform. Whenever we Google for results or academic papers or a restaurant, we use, in most cases, Google's search engine. And the typical model, the typical business model for the operation of all these platforms is to offer free services to consumers, to users. But of course, there is nothing free in this world. If they provide free services, they also need to cover their costs. So that immediately creates a problem. Who will pay for those costs? Well, this business model is based on covering of costs through revenue, which is generated from fees that are charged to the sellers, to business, or from advertising revenue by enabling businesses to advertise on the platform. Well, of course, the result of that is that the free services attract consumers and they make the platform very essential for the businesses and the sellers that want to reach consumers. And so far, so good. We all benefit from it. But that also creates a particular problem. And the problem is the fact that there are network effects. The bigger the platform, the more useful it is. The bigger the platform, it enjoys economies of scale. That is, the cost per unit declines as the platform grows. There are also economies of scope. If you remember, Amazon began as an online bookseller, and now you can buy everything on Amazon because it makes sense to go to one online operator, and from that online operator to access whatever product you want to purchase. These network effects, the economies of scope, the economies of scale, lead platforms to become very large, and they acquire very large market share and market dominance. Therefore, of course, consumer benefits, business benefit because they have access to more consumers, but there is a downside to that. And the downside is that consumers may be exploited. Facebook, for example, or Google may use our personal data for other purposes which are not authorized by us. Or we can experience the so-called lock-in effect, where because Amazon, from which we have bought so many books or so many other items, knows exactly our address, we don't have to, and our financial details, our credit card is also registered there. We don't need to worry about verifying ourselves. With one click, immediately the transaction is completed. So we're not going to migrate to another platform, even if we suspect that our personal data may be exploited for other purposes. But as these platforms also become very large, they may also prevent other competitors from entering the market. Microsoft, some years ago, was found to be abusing its dominance because it tied the operating system to the use of its music player. Google has also been found to be abusing its dominance because it gives preference, priority, and visibility to its own products rather than the products of potential rivals. And the problem is compounded by the fact that it's not easy to determine in every instance whether the costs from these monopolistic practices may outweigh the benefits we all enjoy by transacting online. And on top of that, it's not easy to enforce the normal competition rules because normal competition rules apply ex post. An infringement of law must first occur before competition authorities may enforce competition law. Where we do have a society a preference for preventing the problems before they arise, rather than wait for the problem to arise and then try to remedy ex post. But that's how competition rules apply. They always apply ex post. So what is the solution perhaps to this problem? Well, the European solution is regulation. And the regulation is in the now well-known Digital Markets Act, Regulation 1925 of 2022, which has two major objectives: to prevent distortions of competition by preventing the operators of large platforms from excluding competitors. And also the second objective is to ensure fair treatment of the users of our personal data, for example. And the regulatory obligations are defined in the Digital Markets Act, whereby the operators of large platforms have to conform with certain requirements before there is a problem. And the Digital Markets Act also confers certain oversight powers to the European Commission to police the behavior of the operators of large platforms. The DMA, the Digital Markets Act, came into force in November 22 and has been applied as of May 2023. I should also say that the normal rules of competition also apply. So we have a situation now where the law of competition applies in conjunction with this regulatory act of the European Union. Now, the Digital Markets Act is a fairly long regulation, but it can be distilled in basically three sections or three fundamental characteristics. The first fundamental aspect is that it defines what core platform services are. And if you see, I'm not going to go through the list, do not worry, but if you see on the screen, the core platform services are basically everything we use every day in our digital lives. And the second aspect of the DMA is that it defines the so-called gatekeepers. The gatekeepers are the operators of these very large platforms. And a gatekeeper is an operator that satisfies 4 criteria. The first one is that they must have significant impact on the internal European market. Now, what is significant impact? One can debate that for days on end. The DMA makes it easy to determine whether operators have a significant impact. It simply defines a turnover, an annual turnover in the European Union exceeding 7.5 billion euro. So if a platform operator exceeds that threshold, then it's presumed to have a significant impact on the internal market. Second criterion is that it must provide core platform services. So you saw on the previous slide that core platform services are basically all the services we use on a daily basis. However, this goes a little bit further by saying that the services provided are indispensable or of use or significance to many consumers in the European Union if the monthly active users exceeds 45 million and the annual business users exceeds 10,000. And lastly, the platform must have an entrenched and durable position, which means that in the internal market, which means that the thresholds, the numerical thresholds in the first and second criteria must hold for at least 3 years. Now, once a platform is classified as a gatekeeper, then they have an obligation themselves. So they themselves have to determine whether they qualify on the basis of the criteria, of the numerical criteria, and then they must tell the Commission. They must notify the Commission and tell the Commission, according to the criteria, I am a gatekeeper. And if that is so, then the DMA, and this is the heart of the DMA, the core of the DMA says these gatekeepers may not do many different things. Like, for example, process our data for services or purposes other than those that we have explicitly authorized the platform to do, or prevent competitors or business from accessing consumers on the platform. There are these obligations span several pages, so this is not the time to go through them in detail. The DMA also confers certain rights to the Commission, certain powers to the Commission, that the Commission may monitor, investigate, and also investigate complaints by consumers or potential competitors of the core platforms. And it has teeth. It has power to impose fines up to 10% of the annual worldwide turnover of these platforms. And if the Commission issues a decision and the platform operators fail to comply, then it can impose periodic penalties up to 5% of the daily worldwide turnover of the platform. Since the beginning of the DMA coming into force and until the beginning of this month, the Commission has designated 7 platforms as being gatekeepers. And the list you see on the screen will not surprise you, I'm sure. Google, YouTube are very prominent, Amazon, Apple, and Apple Store at the same time, Booking.com, ByteDance. I had to look that up because I didn't know what ByteDance was. Well, it is the owner of TikTok, Facebook, Instagram, WhatsApp, and of course, Microsoft with its own operating system and LinkedIn. Since the coming into force of the DMA, the Commission has had a number of investigations, but in April of this year, the Commission, for the first time, imposed penalties, imposed fines on two operators, Apple and Meta. Apple, because it prevented developers of applications from informing consumers of other applications outside Apple Store. That was found to be distorting competition. And the other case concerned Facebook and Instagram, and of course Meta, who is the owner of Facebook and Instagram, because Meta also abuses dominance for not giving consumers the option to choose for a less sophisticated service, a simpler service, instead of the option that were given. Either they had to pay, or they had to accept a service full of advertisements. So the Commission found that, in fact, Meta should have given consumers a third option, a free option of a simpler service without cost. In the same decision, the Commission concluded that Meta on Facebook also had a marketplace, but that could not be classified as a gatekeeper because the number of business users was less than 10,000. So that was the first case where we've had a gatekeeper being declassified as a gatekeeper. Now, what shall we make out of this? Is this good? Is this bad? Well, on the whole, it seems that the DMA has been rather successful in forcing gatekeepers to be more transparent and in forcing gatekeepers to be less accommodating of the requirements of competitors, and also the ability and giving access to competitors also to reach consumers via the core platforms. However, the DMA has also been criticized that it imposed too many obligations, so it's an regulatory overreach, that it does not really distinguish between the markets and the services which are contestable and the ones that are not contestable. And lastly, it has been criticized for not also defining conditions whereby gatekeepers or platform operators can cooperate with each other without infringing competition rules. So, to conclude, in order to address the tendency of digital platforms to grow and become dominant, and by becoming dominant to be able to prevent new competitors from entering the market, there is a need for some ex-ante regulation in order to enable competitors to enter the market, and also enable us to require these operators from protecting our personal data and not using our data for purposes other than the ones that we have explicitly authorized. The DMA will evolve, of course, and will evolve on the basis of the practice of the Commission and the experience that the Commission will acquire over time. So this is not something which is cast in stone. I expect we will see modifications in the future. Thank you very much. I will now stop sharing my screen and give the floor to my colleague who is going to be the next speaker. Irini, I think you're muted.
Okay. No, can you hear me now?
Yes, now.
Okay, okay. Thank you very, very much for a very interesting presentation. We see that this is an area that evolves very, very fast. So we have many developments, and this is also the nice thing about this course, the main Tech Reg, because it's going to be a very dynamic course that is going to take into account the latest development. And from the experience we have with DL courses, we see that these latest developments may not always be, if they're very, very recent, for example, a few days old, may not be in the actual materials, but they are put online on forum discussions. So students, in fact, can discuss the latest developments with the person teaching the particular course, which makes that very, very useful and interesting. I just also wanted to say that when we started designing this course, we initially designed that as an LLM, but then we thought the lawyers are only a fraction of those relating or involved to technology regulation. And then we extended it and we made it an MA that addresses, in fact, various different disciplines. And we made a list of these disciplines. But at the end of the day, I cannot actually see who may not be involved, because all these new technologies and platforms are so much into our lives that everyone wants to know what are the obligations or the freedoms one has in this particular area. And now we will continue with the assistant professor, Dimitrios Koukiadis. Dimitrios Koukiadis works for the University of Nicosia, and it's an adjunct professor of law at Goethe University at Frankfurt Main. He has studied at the Aristotle University of Thessaloniki, at Northwestern University, at Harvard University, and at Oxford University, and will be talking to us today about artificial intelligence and legal technology. Dimitrios, you have the floor. In fact, the floor.
Thank you very much. Can you see the
Yes,
slides?
we can. Yes, just put it full screen and.
Okay, thank you very much. And thank you, Ms. Professor Stamatoulis, for your introduction. And actually, I think it was the best possible introduction for my topic, because when I was thinking about what to talk about, I decided to talk about a multidisciplinary subject, since our master's degree also aspires to have a multidisciplinary approach and objective. So my subject is artificial intelligence and legal tech. All right, why the change? Okay. So first, artificial intelligence. Artificial intelligence, a few words about artificial intelligence as an introduction. We are all familiar with the term in the last, at least in the last 4 or 5 years. Artificial intelligence, according to Sundar Pichai, the CEO of Alphabet, is perhaps the most profound technology humanity is working on, and more profound than fire or electricity or anything that we have done in the past. And we call it also a disruptive technology. I choose also this kind of characterization of this technology, because it is a technology that not only improves and develops what already exists as an industry or as an economy, but displaces an established technology, shakes up the industry and groundbreaking products, and creates a completely new industry, and at the same time transform the existing one. So it's not just a new version of what we've known so far, but something completely new. It's exactly what happened in the other 3 industrial revolutions before the fourth one. In the first one, we had the steam engine. In the second one, we had the electricity and the telephone. In the third one, we have the computers. And in the fourth one, now we have the internet and artificial intelligence. So artificial intelligence is what is disrupting not only economy, not only the industry, but also all aspects of our human daily lives. Now, legal tech. What do we mean by legal tech? Because our subject is AI and legal tech. Legal tech is a subject which I could say brings together the legal profession, computer science, business management, and policymaking. So all these three disciplines, I think they meet under the umbrella of this term, legal tech. Legal tech is an acronym for legal technology and means the transformation of traditional legal processes into streamlined and efficient systems, legal research, tools, e-discovery, document automation, practice management software have become standard in most law firms. So these are only some aspects, some dimensions of what we call legal tech. In order to have a more, let's say, broader view of what legal tech includes and encompasses, here we have a small sketch. We have the branches of legal tech. What could possibly legal tech include? E-discovery, transactional review, repapering, contract review and negotiations, contact dashboards, litigation research, predictive analytics, brief drafting, patent creation, witness analysis, fraud detection, and billing analysis. And these, again, I repeat, they're only some of the services, some of the help that technology may add and may offer to the legal profession and to the computer science profession. Because we cannot have legal tech not only without lawyers and the legal industry, but also we cannot have legal tech without people from the computer science sector. AI has enhanced the efficiency of the legal sector. AI-powered chatbots are now handling customer queries, while AI algorithms are used in predictive analytics to determine the potential outcome of cases. And in this first part of this slide, underline, please, the word chatbot. We're going to see it in a minute, because chatbot will not be what is till today and a simple, let's say, software program or an algorithmic analysis of data, but something more. And we're going to see that in a minute, in another slide. AI has also become a staple in the legal industry, with applications ranging from predictive analytics to natural language processing. Generative AI, a subset of AI, is now pushing the boundaries of what is possible. Generative AI systems can generate new content, such as legal documents or contract, based on learned patterns and data inputs. This speeds up the drafting process and reduces the risks of human error. A very important aspect of what we're talking about now, and a very important term, actually I would say the most important term of the whole concept of AI, is machine learning. It's still machine learning. Many believe that machine learning is something of the past. And now we have overpassed machine learning, and we're somewhere else in the superhuman intelligence, super AI intelligence, deep learning, enhanced learning, and so on and so forth. We're not there yet. If we want to distinguish between myth and reality, we're still in the level of machine learning. Advanced machine learning, yes. Deep learning, yes. Enhanced machine learning, yes. But all these are just different forms and versions of machine learning. Machine learning is a subset of AI. We have AI, the broader term, then we have a subcircle, machine learning, and within the machine learning, we have deep learning and enhanced learning, and the chatbots that we are using today. So machine learning is a component of AI. It's being utilized in contract analysis, identifying patterns and anomalies faster and more accurately than human counterparts. Sophisticated AI tools are expected to handle complex tasks, such as legal reasoning and decision-making, which will further augment the capabilities of legal professionals and potentially transform the role of lawyers. Now, what are the benefits of this meeting of the legal technology with AI? Customized legal services. AI can help lawyers provide more personalized services to their clients. For example, AI can analyze a client's specific circumstances and preference to provide tailored legal advice. Very important terms here in this first paragraph. Personalized services and tailored legal services, tailored legal advice. 24/7 availability. AI-powered chatbots can provide round-the-clock customer service, answering common queries and providing information to clients at any time. An AI chatbot does not feel any hunger, any thirst, is never tired, does not want any leave, and is always there. Enhanced decision-making, another benefit. AI can analyze vast amounts of data to provide insights and trends that can help lawyers make more informed decisions. Risk management. AI can help identify potential legal risks and issues before they become problems. These can help organizations mitigate risks and ensure compliance with the legal regulations. What we've been talking so far can apply not only to law, but also to many other industries which have legal departments and deal with issues that are very closely connected to AI. All right, it's not only about lawyers, what we're talking here about. Knowledge management, another benefit. AI can help law firms manage and utilize their vast amounts of knowledge and information more effectively. Innovation. The use of AI can drive innovation in legal services, leading to the development of new business models and services. And here, a very important slide. That was what I told you at the beginning to underline and highlight in this presentation. Chatbots. Chatbots are not anymore the initial chatbots we met when generative AI appeared 4 years ago. Chatbots nowadays are the vehicle, the tool, which are going to lead us to the next level of AI, which is agentic AI, AI agents. And these AI agents are not only to be used in the legal profession, in a law firm, in a lawyer, but AI agents will be the basis of what banks are going to be offering tomorrow. Shipping industry, logistics, factories, all sectors of economy will be based on AI agents. And these AI agents or agentic AI will be based on chatbots. So that's why chatbots is not only another form of AI technology, but is a new form of AI technology, as they are trained in human language, tone and context using natural language processing. They're most commonly deployed to automate candidate screening, improve service delivery, and avoid human interaction to save cost. A chatbot can be programmed to carry out initial interviews by asking specific questions about a candidate's qualifications and history, such as work, experience, and previous company details, and then match them against the job requirements. So whenever you work, no matter if you were computer science or a partner in a law firm or an HR manager, human resources officer in a big company, whether you're working in a shipping industry, in a bank industry, these kind of services will be at the heart of what you will provide in your clients tomorrow. Now we talk about the benefits. Let us talk briefly also about the challenges, because not everything is, let's say, perfectly made in a paradise. Challenges and risks and dangers. Personal data process. AI system, as Professor Nikolaidis also mentioned, data is the heart of what we call digital economy, lies at the heart of AI technology. Without data, we have nothing of what we talked about today. Data is the basis, the heart. Not only personal data, but any kind of data. But specifically personal data are, let's say, more prone to danger because they affect us as persons. So AI systems often rely on large amounts of data, which can include sensitive or personal information. Ensuring these data is collected, stored, and processed in a secure and privacy-compliant manner is a significant challenge, perhaps one of the most significant challenges. Ethical concerns, not only data concerns, but ethical concerns also. AI systems learn from data, and if that data is biased, the AI systems' decisions can also be biased, which can lead to unfair or discriminatory outcomes and perpetuate patterns of discrimination, for example, against women, certain age groups, people with disabilities, or people of certain racial or ethnic origins or sexual orientations. Discrimination and bias is also a very common danger and risk with all AI, with not all, but with most of AI applications. Transparency and explainability. AI algorithms, particularly those using machine learning, can be complex and difficult to understand. These lack of transparency, often referred to as the black box problem, can make it difficult to explain how the AI arrived at a particular decision. What did AI use in order to reach a specific decision? What data? What algorithmic process? What were the training data? Do you have a right to access these data, this information, or not? So here is where explainability and transparency conflicts with other rights, intellectual property rights on the other side. So how do we lose these situations? How do we resolve these issues? With balancing of rights. Job displacement. There are concerns that AI could automate tasks currently performed by humans, leading to job displacement. While AI can create new jobs, it can also render some roles obsolete. So it's the two faces of the same coin, or of job displacement. Dependence on technology. Over-reliance on AI can lead to a lack of human oversight and the loss of essential skills. It is important to maintain a balance between AI automation and human involvement. It's what we usually call in this jargon, in this vocabulary, human in the loop factor. Regulatory challenges. The rapid pace of AI development can outstrip existing legal and regulatory frameworks, leading to a gap between what AI can do and what the law allows. The DMA, what Professor Nikolaidis talked about, is one example. DSA is another example, Digital Services Act. GDPR is another example. AI Act is another example of regulatory steps taken by EU in order to regulate this vast ecosystem of digital economy, which includes AI. Fairness, another challenge. Fairness has to do also with bias and discrimination. So I'm not going to focus more on that because also of the time limit. But what is fair in what we use as data within an AI process is also very important, one of the most important challenges. And the notion of discernment, what kinds of fairness to choose between in cases of reasonable pluralism, is also very important. Judicial decision-making, also a very important aspect. It is essential for the administration of justice that the decision is made by a human being and not a machine. That a human being is appointed by a process that has the trust of the public and involves above all an ability to listen to convincing arguments. Weigh up the points made, decide on the facts, and apply the relevant law. A distinguished professor in Northwestern University of Chicago, Anthony D'Amato, asked the question, can or should computers replace judges? He asked what would be gained and what would be lost, and quickly concluded that decisions and facts must be the province of humans. He pointed to aspects of human judgment that cannot be reduced to algorithms and concluded that such systems should not be encouraged. Again, in the same logic, what Professor John Zelensnikov in 2017 also stated, that judicial decision-making should be based also on human reasoning and on human inspection. Now, what I have here is a slide that brings together what I told you at the beginning, many disciplines together. The legal discipline, computer science, business management, HR management, and policymaking. These, what you see on the screen, are only some of the new professions that are already born or will be born in the years to come, thanks or because of or due to AI. Choose whatever conjunction you wish. But AI has already given birth to these professions or will give birth to these professions. Legal digital tailor, meaning smart client matching, curated business services. It looks like a service that's provided only by a law firm, but it can be in any firm, client matching. Here is about clients in law firms, but it can be about any client matching in any kind of business. Legal developer, legal engineer, legal tech developer. A very important, perhaps the most important aspect of profession, of the future professions that are about to come. Excuse me, because I see a slide here.
Dimitri, are you concluding?
Yes. 2 minutes. Prompting. At the heart of these profession lies prompting. Legal prompting and prompting engineer. So I'm not going to say more, perhaps in the questions afterwards. Cyber cities analysts. Cyber cities, a very common and very new phenomenon. Toronto, Dubai, Vienna, New York, Amsterdam, Stockholm, all these and many more are considered to be cyber cities. They need a backbone of many sciences to support these kind of cities. Personal data broker, information broker, AI ethical sourcing manager, and quantum AI analysts. So I'm not talking in details about these professions. If you have any questions, I'll talk about them after my presentation. But this is only a small sample of what we're going to experience in the years to come. All right, I've concluded my 15 minutes, Ms. Professor Matudi.
Thank you, Dimitri. That was a very good and very helpful overview.
Okay, I skipped the last slide for the discussion, perhaps, or for the future discussion.
Yes, I think we can use.
Thank you for your attention.
Thank you very much. We can use the remaining of time to take questions from the audience. You can either post your question on the chat section, or you can raise your hand and I will take your question. So whatever you prefer. So are there any questions? There can also be questions of a general nature or questions for the MA, whatever you like. Here I have a question from Andrew Michael Baines. What is the contested, let me open the chat. What is a contestable market? So who wants to take this question?
I suppose it's for me.
Yes.
Because I mentioned that term. A market is contestable when it's easy to enter it. Despite the fact that there may be one operator, for example, appears to be a monopoly, but is still contestable. I give you an example. Some markets, like municipal transport market, where you have a municipality that awards a contract, a single contract after competition to a bus company to provide transport services, that appears to be a monopoly. But in fact, every time that the contract is renewed, anyone can compete for it. So it is a contestable market. However, try to break into computer operating systems. Well, you will have to have the same ability, the same knowledge, the same reach as Microsoft. That is not really a contestable market because I'm used to Microsoft. I'm used to Office, for example. Most consumers, most users of computers are used to Office and Outlook. Anyone who can provide a free software perhaps will find it extremely difficult to persuade users of today's computers to switch to new software, which could mean that our existing computers become obsolete. So that is two examples of what is contestable and what is non-contestable.
Thank you very much. I see another question, a follow-up question. The cost of entering the market. I guess you're asking whether the cost of entering the market is a factor that is taken into account in order to consider whether the market is contestable. Is that what you mean, Mr. Baines? Exactly. Good. So if you can, Professor Nicolaides, provide an answer.
I'm afraid the answer is slightly more complicated. It's yes and no. Yes, of course, a company that considers entering the market to compete with the incumbent operators has to take into account the cost of entry. But what makes some markets non-contestable or very difficult to be contestable is that the incumbent had a certain cost of entry, but because the incumbent becomes very well known and the users of the product become dependent on the product of the incumbent, the cost of entry of the next competitor increases. So it's not like it's not the same cost when two companies enter the market and then the most efficient win. It's just that with some products, we all become so completely dependent on them that the cost of entry for the next company becomes astronomically high. And that is what prevents competitors from breaking the stronghold of companies like Google or Facebook, for example.
Thank you very much. I see another question about the course. Does blockchain, let me see, does blockchain get highlighted as well in the course? And if so, how? Absolutely. Blockchain is one of the technologies that are taken into account. AI, Internet of Things, blockchain, NFTs, big data, virtual reality, expanded reality, mixed reality, 3D printing, metaverse, etc. And the aspects differ because we have approaches from intellectual property rights, for example, whether in relation to NFTs, whether they are protected by copyright or not. We have a human rights approach, we have data protection approach, we have competition approach, also in relation to cybercrime, and so on and so forth. So depending on the course, there are different approaches in relation to blockchain technology. I don't know whether I have answered your question. If you have any follow-up question, please feel free to post it. In the meantime, I'll move on to the next question. Does the DMA, as people have criticized, risk regulatory overreach by violating proportionality or subsidiarity in EU law? I think this question is again for you.
Yes. In fact, I think certainly it does not violate subsidiarity because, in fact, it makes it it clears the regulatory landscape for platform operators. If we would allow 27 member states to come up with their own rules, we would have created a patchwork of regulatory of regulations that would have, in fact, segmented the internal market. So for sure, it does not violate the principle of subsidiarity. I have to confess, I find it more difficult to answer the question on proportionality. I think it's perhaps early days now to conclude that it's either we have either regulatory overreach or that the obligations which are imposed on platform operators are disproportionately cumbersome. I can see the argument. I appreciate the argument. I think there is an element of truth in this argument, but I don't think that at this stage it has been proven that we have gone overboard. We have gone to the other extreme of regulating too much. In fact, I think in some cases we probably need even stricter regulation. But the issue of proportionality will come back again, and perhaps in a year's time, if you take the course, I will be able to answer this.
Thank you very
Can I
much.
say something? Can I say something on that?
Yes, Dimitri.
I find this question a very important question because it touches on the relationship between the EU regulation and national regulation. So what I would briefly like to say is that we, at least the ones who live in the EU, in an EU nation state, we have the privilege of being protected by many levels of constitutionalism, many levels of lawmaking. We have the national lawmaking, we have the EU lawmaking like DMA or DSA or AI Act or GDPR, and we also have international law. All these three levels of protection coexist with each other. They do not contradict each other. Of course, we have a level of superiority. EU law is superior than national law, and international law, depending on the international law, sometimes superior of EU law. But all of them exist in order to protect our rights. So subsidiarity is very well served through this kind of EU regulation.
Thank you very much. We'll proceed with the next question. Should AI progress be slowed down via legal measures to ensure a less dramatic transition to the new age? I think this is something you will allow me to give a first reply, Dimitris. I think this is, you cannot in fact slow down development. What you can do is you can regulate development. You can try and make sure, although you can never make sure, that the way things progress are ethical, are fair, take into account the parameters they're supposed to take into account, but you cannot actually stop progress. That would fall foul on many, I guess, legal bases. But Dimitri, do you want to give your view?
Yes, of course. Well, I agree with Professor Stamatou. AI is like globalization 20 or 30 years ago. There was a question about 30 years ago, can we stop globalization? Can we stop internet? The answer is no, we cannot stop it. But what we can do is to find a balance between innovation, between profits, between the benefits of AI and all these kinds of technologies, like blockchain or big data and Internet of Things, for example, a balance between the benefits of these technologies and the protection of our rights. This is the golden standard. This is the most difficult goal we are about to achieve and we need to achieve. Not to stop AI, but to make it, of course, profitable, beneficial, but at the same time respecting at least the fundamental rights of the users and of the citizens. And that is what is at the heart of the EU regulatory initiatives, at least in the last 7-8 years. Finding this balance, this golden balance between innovation, profits, and fundamental rights protection.
And I see we have another question. How do you see the EU's AI Act shaping the global standards for ethical AI development, especially in high-stakes sectors like law and medicine?
Well, yes.
Dimitri, you want to answer that, and then I can add certain things.
I think this question touches on a very sensitive and perhaps, to my opinion, one of the most revolutionary aspects of AI, which is AI and medicine. What we are going to experience in the next 10, 20 years in the medical sector with AI, I think we cannot even fantasize that today. So, Law AI Act does not only provide the law, but also the ethics. And perhaps it's the first time we have an EU regulation or an EU legislative act in general, which gives to the ethics standards, to the ethical dimension, an equal position as the legal dimension. Ethics and law walk together hand in hand in AI Act. We cannot separate the one from the other. I don't know how in practice that's going to develop, how it's going to evolve, but the target, the ambition is for both of them to work together and to protect as much as possible our rights, and specifically in sensitive sections like the medical one.
And I would also like to add that there are certain things that are not very clear, of course, in the UA Act, because it provides for some codes that need to be drafted, some guidelines that need to be made more specific, etc. So these are under evolution and involvement. So it's still early days, but what is important is that by regulating or trying to regulate AI in the European Union, this sets an example also for other countries to start working in the area. And in fact, it helps very much companies setting a regulatory benchmark, right? And a risk-based categorization. All these are extremely useful in that particular area. Let me take the next question regarding the program you presented. What is the practical impact or benefit that the student can expect to gain upon its completion? I mean, how does the master translate into real world skills and professional opportunities? Well, in fact, it prepares graduates, and not just law graduates, for roles such as legal counsel, legal designer, IT designer, computer scientist, business manager, political scientist, legal compliance officer, plus the skills and professions that Dimitris Koukiadis has mentioned. So in fact, it becomes very competitive on the international market, because nowadays we're not talking about national markets, we're talking about international market, and someone competes on the international market. So whoever has the latest knowledge in the field is the most competitive, in my view. And this is exactly what this MA offers. I don't know whether we have covered all questions. I see there is one more. What do you think about the role of prompt engineering profession in the future? Because AI is useful if the correct and understandable guidance is provided. Do you mean that is AI useful if the correct and understandable guidance is provided? Is that what you mean? Ertan Aslan?
Can I say something on that?
Yes, go ahead. I guess that's what they mean.
Prompt engineering or prompting in general, I think will be the basis of education, of all levels of education, since elementary school, high school, university level, and of many, if not of the most jobs. Because prompting engineering is going to focus on how to develop and how to create the best possible prompt in order for you to get the best possible answer. Whether that is generative AI, whether that is predictive analytics, or whether we're talking about a simple decision making. All these will be based on prompting. So whoever becomes an expert in prompting engineering, I think he or she will be a master of his or her discipline. Now, regarding the issue of guidance, well, this is the meaning, that's the meaning of law and ethics. Learning the law and ethics of prompt engineering will make you use prompting in the best possible and safest way in order for you to be covered from any illegal use of prompting.
And of course, what means illegal use of prompting is not clear. We have a case which is open now before the Court of Justice of the European Union, where it is discussed whether you can put extracts of other people's work as prompts in a system, and in particular, it is about Gemini, and whether that, in fact, violates other people's rights. So you see many more things are prompting and are popping up, in fact, in that particular area. I see another question from Yolta Seas, and this is the last one we will be taking for today because we have exceeded our time. How fast and effectively can the DMA apply to foreign gatekeepers, particularly dominant US tech firms, given jurisdictional and enforcement limits? Is there anyone who would like to, perhaps Professor Nikolaidis, you would like to give the answer?
Oh, yes, they will have to comply. The European Union is the largest single market in the world. If they want to offer services in the European Union, they will have to comply. And in fact, we have a lot of precedents. The European Union's competition rules, especially the merger rules, apply to any company in the world that does business in the European Union. And we've had many cases of the European Commission requiring companies to demerge or prohibiting mergers between American companies, and they never refuse to comply. The United States doesn't like it, of course, but
exactly. That's why Trump said we innovate and you regulate.
Yes, that's right. Well, if you see the level of protection for consumers in the United States, I wouldn't like to be under the very almost non-existent regulatory protection there. Of course, that does not mean that what the Europeans do is perfect, far from it. But I would rather be protected rather than be left to the mercy of these very large companies. There is one more thing I would like to say in response to a question earlier. What kind of skills do we get? And if I'm outside the European Union, are these skills useful to me? I think the answer is yes. I have a colleague who is an expert on GDPR, the General Data Protection Regulation. And over the past decade, he's been going around the European Union providing training to public authorities that want to, and companies that want to comply with this regulation. And the past 2 years, he's been going, let me name 3 countries, Argentina, Kenya, and Indonesia, because they also export to the European Union and they also have to comply with EU rules. So, yeah, it is a fact of life, I'm afraid. Whether we like it or not, it's an issue, it's a rule that we need to comply with. Thank you.
I would like very much to...
A small comment on that. Two words.
Okay, 2 words.
EU law, since GDPR, is not only EU law anymore, it's global law. GDPR is applied in 150 nation states outside the EU. So, and the same is the same ambition we have for AI Act. So, learning about EU law is not only for EU citizens, but it's for the whole world.
I would first of all like to thank the Distance Learning Unit for actually supporting this webinar. I would like to thank them very much for their technical support. I would like to thank the speakers for their knowledgeable insights and expert, in fact, presentations. I would like to thank very much the audience, the state, up to now remained with us, and I would like to wish everyone a very nice summer. Thank you very much for joining tonight. Thank you. Bye.
Thank you very much. Thank you. Bye-bye.